Yeah, you're all hearing good. You know, today's lecture is being taped, and that's why we are having this little dance. But this is the first of our Supreme Court series. So you know there are going to be 3 lectures, and let me remind you that the next one is going to be on a Thursday, the 28th of September. That will be Amanda Tyler from the law school. And the 3rd one will be on Monday, October the 9th. And that will be Jack Citron from Political Science. Our speaker today, who's launching the series, is the very distinguished former dean of the law school, Jesse Chopra. He's been professor of law at Berkeley since 1965. His training was at the University of Pennsylvania, and he was law clerk to Chief Justice Earl Warren in his younger days. He has visited and taught and lectured at many universities throughout the world, being an international authority on constitutional law. His venues have included Italy, Spain, Netherlands, Australia, Switzerland, Portugal, etc. And of course, he's delivered titled lectures at many American universities, about 20 of them. He's received a Berkeley Campus Distinguished Teaching Award, and he's received the University of Pennsylvania's highest award for an alumnus. He's been vice president of the American Academy of Arts and Sciences, and he's been Cal's faculty athletic representative to the Pac-10 and to the NCAA. But the thing I like best is that he has also been appointed twice by 2 governors, Schwarzenegger and Brown, to the California Horse Racing Board. So he is an authority on horse racing. But today he's going to talk about the Supreme Court. Jesse Chopra.
Well, thank you very much for that nice introduction. They said a lot of nice things about me that I appreciate, and I think a bunch of them were true. But in any event, I want to thank you for coming out. I know that I saw 1 or 2 people said, I thought this place, new building, was going to be air conditioned. So I figured that was probably an attraction to do anything in Berkeley today. But here we are, and I will try to conserve the hot air as much as I can. So, I put a title on these lectures. This is, I have been, I guess, for nearly 35 years, been giving lectures like this on the prior term of the Supreme Court. And the title that I put on this is the most unusual Supreme Court term in my 58 years of teaching. So I hope that that's a good beginner and catch your attention at least for a while. I want to do 3 things in the course of this first hour. One, I'd like to discuss what I would call the uniqueness of this term of the court, the 2017 term. It's technically the 2016 term because it began then, but this will be referred to as the 2017 term. In these lectures that I've been giving, I would ordinarily discuss the 5 or 7 most significant cases of the term. There's a limited amount of time to say a lot of things that you can do. And I used to, agonize over trying to pick the 5 out of the 7 most significant cases, at least constitutional cases I'm confined to. But this was pretty easy. This term, there was really only one of any case, constitutional decision of any real significance. We're promised several more in the term that will start on the first Monday of October. As you can, the orders in respect to immigration is a big one. There's another big one coming up involving districting, which is a critical element in who gets elected to what. And, but anyway, that's if there's any time that we have when we have the questions next hour. I'm happy to talk about that too. But as I say, there was only one during that time. So what I would do is I'd discuss that one case, and then, as indicated, take any comments that you have. And some people, I mean, there's certainly, criticisms are included among comments. And I've learned that you can't fool all the people, please all the people all the time. So the court decided 71 cases last year, altogether. That is not an unusually small number of cases, but it is on the low side. The fact of the matter is, Professor Clubb indicated that I had clerked for Chief Justice Warren. That's a few years ago, 1960-61. The court decided 150 cases that term. So we're talking about, and this is not this term either. They've just cut back over the years each time. Sometimes, I would say as few as 65 cases. But it was 71 this year. Well, and anyway, this is not an unusually small number of decisions. I count of those decisions the ones that I really want to talk about, or at least want to refer to. 23 constitutional decisions. Those are decisions that decide, that ruled on constitutional questions. That's 23 out of 71. If you say, well, what are the others? Well, the others, they're the less high-profile cases, but they interpret statutes. That's probably federal statutes. They interpret the, federal rules of evidence. All of that is within the Supreme. Those are all not constitutional questions, but they are federal questions. Who else is going to interpret federal statutes but the United States, but the federal courts, ultimately the U.S. Supreme Court? And a lot of very high-profile cases are statutory cases, and they just get decided on statutory terms. What is the difference between a statutory decision and a constitutional decision? Is really very simple. A statutory decision can be changed by an ordinary act of Congress. That is a lot more difficult, as I'm sure we all know, than it's been stated, but nonetheless they can be changed. They can be changed through the democratic process. A constitutional decision can only be changed in two ways. One is the court can change its mind, and it does that periodically, and that's a whole area of controversy as to when can you overrule a case and when can you not overrule a case, and so forth. But you're not supposed to do so willy-nilly. You're supposed to observe precedent. That's the guiding light, the presumptive approach to these things. But okay. So, and the only other way is by constitutional amendment. And that, on any controversial issue, I should say, is virtually impossible. The biggest ones were the third, which most of you are familiar with, the 13th, 14th, and 15th Amendments. That was the post-Civil War amendments. Well, those were big ones. That put into the federal area things that were previously reserved to the states. Said no state can deprive any person of life, liberty, or property without due process of law. Due process, that's the mother milk for constitutional decisions, or deny anyone equal protection of the laws, which is the other part. And those are the two big things. You determine whether something violates due process or violates equal protection. All right. So those are important decisions. I count 23 of such cases decided last term by the court. It's a small number, but again, they're not unusually small. But of the 23, they 23 lend themselves to being characterized as producing either a conservative or a liberal result. And I'm going to go into that a little bit. What's the difference? What is a conservative or liberal result? Is it the same thing that we talk about every day in the newspapers? Conservative rulings by the president, and he's done both, I guess, or not many, but some, and liberal. So it's different. I want to say, or at least it has traditionally been different. But I characterize them this way according to the way the courts present factions, and I'm going to talk about the two factions on the court in a moment, the way they actually vote. So let me start, and I'm going to do this one time again, at least, to describe the 9 justices on the Supreme Court in terms of being conservative or liberal in the way that I've just indicated they are. So if we start from right to left, the most conservative, and I'll go into again a bit later what the difference between the two of them is. But the most conservative is Clarence Thomas, who is off. He is probably the leading adherent to the notion of originalism, the original understanding of the framers. And if you're inclined to favor principles rather than, case-by-case decision is the way you like it, but he goes by principles. And I may not agree with him all the time. I don't agree with any of them all the time. But I think, although he's principled, it is a waste of his efforts, because he will come up in certain controversial cases and go back to the original understanding of what happened, and it's pretty accurate. But it's a different country. If you say, what is it that can be regulated by the federal government under its power to regulate interstate commerce? Well, interstate commerce was a lot different 200 years ago than it is today. Today, there's nothing that doesn't have some significant impact on interstate commerce. Even a drugstore that sells toothbrushes, you can go through that. Toothbrushes, druggist has got to buy them someplace, right? Well, there's a big manufacturer someplace. The goods that are produced by the toothbrush by the manufacturer, they're bought someplace, and it affects interstate commerce, has an interstate impact. The court has gone so far as to say haircuts are a matter of interstate commerce. In a case many, many years ago, in which someone went off the road beginning to drive through the South and wanted a haircut, and wouldn't get a haircut because he was black and the barber was white, and they held that was a violation of the Commerce Clause in the 1940s or 50s. Okay, so from right to left, first, as I say, is Clarence Thomas. The second is occupied. It's really 2 and 3. I think they're pretty close to one another. And they are Samuel Alito and the newest justice, who we'll talk about later, Neil Gorsuch, appointed about a year ago. Then if you take we're moving toward the center. The next toward the center, the fourth one toward the center, is the Chief Justice, who indicated that they thought that he was going to be very, very conservative. Well, he's not. I mean, he's conservative, but he's not very, very conservative. And then in the almost the dead center is Justice Anthony Kennedy. He leans right sometimes. He's basically a conservative. He used to be very conservative for some reason. Which is a subject for a different discussion. He seems to be moving gradually toward the left of center. But anyway, he is just on the left side, if you imagine a line, just on the right side, right, of that line of the center. And he becomes an important subject of conversation in just a few minutes, all right? Then you move slowly to the left. The first one over the line, who leans closest to the conservative side but is basically liberal, is Justice Stephen Breyer, a local person, man, who's been there for quite a while. Then there are two more. I'll jump for a minute, for a second, all the way over to the right, and that would be Ruth Bader Ginsburg. She is the mainstay of the left. I mean, the most liberal group. The two just to the right of her are Justices Elena Kagan and Sonia Sotomayor. And I would say they're very difficult to characterize as being one more liberal than the other. Okay. Now, I use these labels, liberal and conservative, again, intending at least not to use it in a term that describes our political process, but it's only constitutional decision-making by members of the Supreme Court. And it's somewhat oversimplified, but I think it's generally accurate as to what I'm talking about. What's the difference? Liberals favor individual rights. Conservatives tend to favor government regulation. However, there's a big qualification of that, too. They have to be non-economic rights that the liberals favor. There, the two sides flip-flop. If it's a non-economic rights or has a great non-economic, or non-economic, let's just say for the time being, then if it's an economic right, then the conservatives favor the individual right, and the liberals don't favor it. If you want a big illustration, it's a case which almost all of you have heard of sometimes about a half a dozen years ago, called the Citizens United case, which involved the question of whether unions and corporations could contribute money to political causes, all right? The courts, the claim was this is an expression of free speech to contribute to people who are engaged in the political process. I mean, we wouldn't have a legislature that operates without many, or at least any single legislator that would operate without any political contributions. That's what they've got to do. You excuse me, I'm going to take this coat off. It beat me. No, I can't. I'll drop it down here. Okay. So there's a flip-flop. When it involved an economic right, that is the right to give money in a political cause, the 5 conservatives got together and say, oh yeah, that's protected by the free speech clause. That's speech. Money is speech. And the 4 liberals says, oh no, it's not. And they voted the other way. I'm going to talk about a case later on. I'll refer to another one, the right of eminent domain, the right to just compensation if they take your property. That is an economic right, favored ordinarily more by the conservatives on the court and less so by the liberals on the court. Now, the rest are not as difficult. Beyond that, liberals favor national power, and as is well known, the conservatives favor states' rights. Ordinarily, nothing is, absolutely 100% one way or the other in any of these things. Similarly, the liberals favor an expansive role for the federal courts. The conservatives are much more willing to leave final resolution to questions to the state courts. Again, that's a question of between liberals and conservatives. And fourth, and this is the one that keeps shifting all the time, conservatives are more likely to uphold executive power versus Congress. At least they were more likely to do it when the Republicans had the White House. There's been some change now that when the Democrats had the White House, and mainly the 8 years under President Obama, all of a sudden there was much more favoring of the presidential power than it was before. So there is a flip-flop that way as well, and it depends on where they are. But there are two things that are very clear. Neither side, the conservatives or the liberals, adhere to this notion of judicial restraint. That is, great deference to the popular view expressed by elected members in Congress. Neither side is deferential. They're just as ready to strike down a statute on the conservative side, and that's activism. That's not restraint. That's permitting 5 justices, which are certainly not representative of society as a whole, to tell the political process, the democratic process, if you want to call it that, no, we can't do this. This is what the Constitution prohibits. So neither side to do that. You get a case that fits into their niches that I've talked about. They can be either restrained or activist. And second, and I think this is an interesting point, I'm not a historian, but both the justices on both sides, to the person, are very smart. I would say that they are probably, as a group, the smartest group. The average smart is the highest, I think, certainly since after the time of the Civil War. That's a long time, even long for me, so, and some of us. And both sides are also highly ideological. That's also true. Very, very ideological. All right. Why was this year the most unusual ones? Let's go back to the 23 constitutional decisions. 10 of the 23, that's nearly, 50%, if you round it off in a way, were unanimous. 6 came out on the liberal side, 3 on the conservative side. 1 is, in my judgment, too close to call. Was it really liberal or conservative? So as I say, nearly 50%. That is the highest level of agreement in over 70 years of our system. So that and more than 70 years includes everything that I've done, anyway, in this area. So it's the highest level of agreement. Let's take a look at the closely split decisions. Usually we're used to talking about a closely split decision, 5-4 decision. Well, the fact of the matter is, there was only one such case that was closely split, 5-4. Why? Because for virtually the entire term, there were only 8 justices on the Supreme Court. All right? So if you want to talk about a close call, it's 5-3. Because if it's 4-4, it's no call. It's got to be different than 4-4. It's, so the closest thing is 5-3. Okay. There are usually about a dozen or more closely split decisions. This year there were only 5. Also, very unusual. Interestingly, too, they were split 4-0 in favor of the liberal side. Big explanation? Well, I don't know. Maybe we'll think about it for a minute. One of them, I say they split 4-0 liberal. One was too close to call. I don't know if it was a liberal or conservative. One of the big features of this term, when they only had 8 justices, was they decided cases very, very narrowly. There were no great big cases. That's why that was a problem. And it was clear to me, and I think that there's some indication that at least some of the justices indicated that, yes, that's right. We're trying to find a middle ground. The 8 of us. We don't want to make big laws without a majority on the court. So they on the other hand, we don't want to leave a lot of cases for the next term either. we want to decide the cases. I predicted, completely wrong, that they would simply put the case over if they couldn't decide it, which means you send it over to the next term. But they didn't do that. When there'd be 9 justices on the court, justice appointed. But they didn't do that. They went out of their way to find compromises among the 8 of them. And that explains very much why this has been a very, very unusual term. I believe it was Justice Alito who quite openly in a conference someplace that was reported admitted this. He said, we're doing things now, this is not a quote, but he says, we're doing things now that we wouldn't ordinarily do. And I think they wanted to show in some way that the government, that the court could operate under very difficult circumstances. You remember there was a justice nominated, I'm forgetting his name, Merrick Garland, was nominated by President Obama before the election, and it was a very whatever you may think of Obama, he's very smart, and very clever. He was not the greatest politician overall, but on this, he really found someone that would be very, very difficult for either side to turn down, and that both sides would love to take him if they were in the minority. And there was no majority at this time. They split 4-4. Justice Scalia creating the vacancy, one of the conservatives gone. It was a very unusual term in that way. There were usually 5-4, or this time 5-3, about a dozen or more such cases. That's usually what you find among the constitutional cases. This year, there were only 5. Again, very unusual. They were split for reasons that I'll go into in a moment. I may have said this before, but that's all right. A lot of people have to listen twice anyway to remember. Anyway, you get the point. Anyway, and they're split 4-0 on the liberal side, 2, and the one was too close to call. The explanation is this. Justice Kennedy, who was usually the swing vote in these very close cases, and he's been so for nearly 20 years, he voted liberal in all 4 cases. Now, why? Well, he hasn't told me, and I don't think he's told anyone else. I would say my guess is it was greatly affected by this effort to decide cases on very narrow terms. The big question remaining in the remaining years of this court is that will this liberal view of his this term continue? Now, Justice Kennedy is 81 years old. As I indicated, he's the 2nd oldest member of the court. Justice Ginsburg is the oldest, and he would have to outlive Trump's presidency, or at least want to stay on the court. Some of you in your 80s, you don't have the same vim and vigor. Some do, maybe, but some don't. And time to take life easier in any event. Well, he has chosen, at least for the time being, not to do so. I would say it's year to year for him. I think it's pretty clear that he does not favor the kind of very conservative judicial appointments that Trump has generally made. All right, but nonetheless, that's the way it looks. And I would say that once again, he's going to make up his mind every year how he feels as to whether he goes on further. But what about the future? There's an old saw that that those who live by the crystal ball have got to learn to eat glass, and I've eaten a lot of glass. in my day. Excuse me just a moment. I would say that as long as the court's present 9 persons stay that way, with Kennedy continuing to be tending to be the liberal-leaning swing vote, you have the 4 liberals on the one side, the 4 conservatives on the other side. I would say that it's no change is going to go on. I mean, you had Scalia on the court before, Justice Scalia. Now you have Justice Gorsuch. We don't know everything about Justice Gorsuch. I mean, he's only been around, he's only decided maybe half a dozen cases, and as I struggled to find one that I thought was worth talking about, they weren't, that was a 7-2 decision, so it's not a big deal, one of them. But I'll talk a little bit more about that in a few minutes. But I would say there's no change. He's very much like Scalia. If you want to look for little spots in which he may change, yeah, there's a doctrine in administrative law called the Chevron doctrine. What does that mean? In a word, it means how, when an administrative agency, which has enormous power in our government, I mean, they make the really important rules. Congress passes relatively vague statutes most of the time, and then they become specific through various sorts of administrative interpretations. They have what they call rules. They promulgate rules. Scalia was very deferential to the administrative agency. That was clear. That was one of his, there was a so-called Chevron, a case called Chevron Oil Company case, which they deferred to the administrative agency. You're the experts on what the statute gave you authority for, and that's the way we're going to give it a heavy presumption in favor of validity. Gorsuch has given very strong indication that he's not going to be so deferential. Will that make big differences? I don't think very much, but some. There'll be cases, a lot of them won't be constitutional cases, but there'll be cases in which that will make a difference. Excuse me. And the second is a probably more controversial issue than the Chevron doctrine, and that is the Second Amendment right to bear arms. That is one of that provision of the Second Amendment is one of the most convoluted wordings that anyone can determine. I actually put it in my coat today. If someone wants to talk about it, I have it marked off because I don't remember exactly what it says. I mean, I know it makes no sense. It talks about the militia, and you have the right to bear arms in order to maintain the militia. That's basically the quick definition of it. And we never had an authoritative decision until about 7, 8 years ago on exactly what it means. And that was a very narrow decision which held only that there is a Second Amendment right to have a loaded gun in your home. Look at those qualifications. In order to protect yourself, your property, and your kin in the house. That was it. It didn't involve carrying a gun down the street. It didn't have, it has to be a handgun, not one of these Tommy guns that they can use and so forth. But, they can do a lot of damage with a handgun, too. But nonetheless, most of the damage is not done in a home. Most of it is done outside the home. So, and anyway, that was a 5-4 decision. 5 conservatives said, see, after all, that is a constitutional right, the right to bear arms. They split. 5 conservatives said, yeah, there is such a right. And the liberals said, well, it says that, but it means something else altogether. Has to do with the militia. No, I'm not going to read it. Okay, we go on. So Scalia was never very clear on that. He wrote a very narrow opinion in favor of the Second Amendment in the key case. But again, it was only in the home. And he said, he went out of his way to say, look, we're not deciding a lot of big issues. For example, whether you can carry a handgun on a street, concealed handgun, or whether you can take a handgun into a public building. I imagine he was thinking about the Supreme Court as being one. He said, we just don't decide these sorts of things. Justice Gorsuch this term joined a dissent by Clarence Thomas to a summary affirmance. What does that mean? That means they took the case up and they decided it, but they decided it without any oral argument or anything. A summary disposition of the case. Usually not paid too much attention to, but it is technically authoritative. Gorsuch joined a dissent. It was a 7-2 decision, saying that this particular sort of handgun problem could be regulated. He joined a Thomas dissent which took a very strong view on the scope of the Second Amendment. So for a lot of people, that becomes important. And what is perfectly clear is that Congress is beholden to the National Rifle Association for money, despite the fact that they don't believe it themselves. I'm sure they don't on most cases. So that's that. And so that's the other thing, the right to bear arms, the rule about deference to the administration agency. Finally, let's take we have about, 15 minutes. Let's take a look at the two constitutional decisions of our new Supreme Court. All right? Neither of these are blockbusters, but I want to tell you this is the term last term and it's the first term of the 9-justice court with Gorsuch on it. It's called Trinity Lutheran Church versus Comer. I want to emphasize it was a 7-2 decision. What did it hold? It was a constitutional decision. The state of Missouri had a law which tried to make good use of scrap automobile tires. That's a big, there are a lot of those things. We've all seen these great big piles of them. Try to do something useful with them, so they found they could grind them up and use them for various sorts of ways. You had to apply by some procedure in the state of Missouri to get some money for it. And to make a long story shorter, anyway, this was a case of a church who wanted to resurface the school's playground. Now, there was physically apart from the church. It was the church school, the religious schools, parochial schools, playground where the kids played. They wanted to resurface it to make it safer for them. And the court held 7-2 that to do this to a church was a violation of the Religious Freedom Clause, called Free Exercise of Religion, because it imposed, I'm quoting from the decision, a penalty on the free exercise of religion, and that, in a 7-2 decision, said that triggers the strictest scrutiny, which really means it's 95% invalid. To be, a quick answer, it's got to have a compelling government interest for an extremely important reason that cannot be achieved by any alternative means. If you take that seriously, which they frequently don't, there's very little that could survive strict scrutiny. But once in a while, you find something that does. Okay, but if this did not survive strict scrutiny, and it was in favor of the church. It was a 7-2 decision. And I should mention this. There's another thing unique about this court. It used to be that it was made up exclusively of white Anglo-Saxon Protestants, all right? It was not until the, I would guess, maybe late 19th century that there became a Jewish seat on the Supreme Court. First occupied by a justice named Cardozo, Brandeis, Louis Brandeis, and then Cardozo. Anyway, there was, and Frankfurter was one of the famous ones, and so forth. Okay. They used to have a Jewish seat, and they used to have a Catholic seat. So all of the rest, up until a few years ago, 15 years ago maybe, were white Anglo-Saxon Protestants. Today, there's not a single white Anglo-Saxon Protestant. There's not, a matter of fact, a Protestant of any color on the court. You end up with 6 Catholics and 3 Jews on the Supreme Court. Very interesting phenomenon. And it doesn't get mentioned. It got mentioned a lot in the beginning, but that's just it's been basically ignored. Okay, so Roberts wrote the opinion. Remember what I said? Kennedy's in the middle, the middle-leaning right. He's next in line. He got Kennedy. Those are the two who lean the other way. Justice Kagan and Justice Thomas, who sometimes stands up for religious freedom. He's also Catholic, and whether that makes any difference, I don't know. Lots of people think that it's impolite or irreverent, if you'll excuse the pun, to talk about that. But look, it's a reality, and the Supreme Court is a reality, and people do talk about these things. And Justice Gorsuch. Those were the 6. Justice Breyer, it was 7-2, where he concurred in the judgment. Now, it was basically, he had a little twist, but he said, I don't agree with everything they said, but I agree with the result that they reached. The 2 dissenters were Justices Sotomayor and Ginsburg. They articulated a stricter view of what we call church-state separation. They felt that even giving the money for this purpose to a church was a violation of the separation of church and state, called the Establishment Clause of the Constitution. And the last case was a case called Pavan against Smith. It was one, again, of a fully reviewed case. It was a summary decision by the Supreme Court, right? They take the case up, they grant what's called certiorari, they take it up, and they decide it all in the same breath, if you will. No oral argument, no more briefing or things like that. And it wasn't a big deal, but it's sort of interesting, to people like me anyway. It involved an Arkansas rule, which required both a father's and a mother's name to be on a birth certificate. Well, if you stop there, that makes sense. And the question before the court was, well, suppose you have a same-sex marriage, and it's a natural childbirth by one of the 2 women who are married to one another. The question is, do you have to identify which of the parents gave birth? All right, you got it? Used to have to, there was no identification of the father and the mother when you had a man and a woman getting married. It's only the woman that could have the baby. But if you have 2 women, you have to identify the parent who gave birth. And there was a law that said you could. And they said, no, that's a violation of the Equal Protection Clause, because you have to identify one of the parents. Even though it seemed to me that the rule's purpose was to identify the parent who gave birth. But it was obviously not the sole purpose, because they did ask for the father and the mother's name under other circumstances. So if all you wanted was who gave birth, it surely wasn't the father, a male father. All right, anyway, the court went on to do this, and Gorsuch did not join the opinion. Rather, this is a summary thing, he dissented along with Thomas and Alito, who are the two most conservative members of the court, and that's why I'd say he's right there. He's going to be pretty conservative, and I'll say something about that. And he said we should have heard full argument on this. He says it's a complex question, and it justifies full treatment. Well, neither of these cases that I've talked about were the classic split of a 5-4 decision. But this one was the first constitutional opinion that Gorsuch wrote, even though it was a dissenting opinion to a summary change. It's not a classic case because both Kennedy and Roberts joined the liberals, but it's closest to the classics. There's another one closest to the classics, which was a 5-4 decision to grant a stay of execution in respect to a man on death row. The court voted 5-4 to grant a stay, which means we're going to have further argument about this, give it further consideration. We all know what a stay is. Last minute, he's scheduled to be executed. He's got a case tonight. He's got a case being heard by the Supreme Court. They say, we'll stay the decision, wait for stay the execution, because we can't do anything about it if we execute him and then find that he was entitled to a new trial. Okay, so they voted a stay of execution 5-4. He was one of the 4 dissenters. He would have said, let's not stay it at all. He's going to be pretty tough in the criminal process, I think, as was Scalia. So once again, it ends up with no change. Well, it's about three minutes out. I guess my assignment here this afternoon was to talk, and I guess yours was to listen. And I hope we finished about the same time. Okay. Thanks very much. Thank you. And we're going to we'll take the break now. Thank you.
Are we ready? Can everyone hear me in the back?
Yes. All right, we're going to begin. We're going to begin the. We're going to begin the question session now. And Chris says there are two mics. She and Carrie both have mics. So if you want to ask a question, just raise your hand, and one of the mics will come to you, and Jesse will answer everything.
All right, we'll start over here. Speak right into the mic when you ask your question so we can all hear.
Hello, can you hear? Is this right? Is this like this? Okay. So I'm curious what you think about a prospective case regarding the Daca regulations. And I've heard that the states have are in the process of bringing a case based on the notion that not due process, but that equal protection has been violated, that the Daca members are currently protected under Daca and as such are entitled to equal protection, but that the member of the group of Daca are almost entirely Hispanic and therefore, entitled to equal protection, which they would not be receiving if it was rescinded. I wonder what your thoughts on the likelihood of that case prevailing or not, or just whatever your analysis is.
Oh, I have a microphone. I was just leaving with it. Well, that's, to date, that's the highest profile case of the term. I can tell you what I think. I said about predictions in the glass. President Trump made a major error that can come back to haunt him. And that was his first order or whatever he did, statement about these, in which he said Muslims. Now, if they hold that against him, which the upcry, and then I think his legal advisors said, that was a big mistake, because that's religious discrimination. And just as in the case that we talked about, religious discrimination is subject to the highest scrutiny. So this would be plainly a loser. It's clearly what you call overbroad. It's sweeping in all Muslims, despite the fact that they may be able to, prove loyalty in the strongest way. I don't think he left it that way for more than 24 hours, in which someone correct me, that's fine. And then he came back and he named 6 or 7 countries. And the argument that his lawyers are going to make is that the president, I have one other thing I want to say first. But they're going to say the president has power to carry out the statutes that the Congress has passed, which gives them authority to regulate immigration. Now, what I should have said earlier was immigration is committed to Congress. The rule by the Constitution, I don't have it, I do have it, but I'm not going to look that one up. But Congress, among the enumerated powers that Congress is given in the Constitution, is the power over immigration and naturalization. Right? They make all the rules for that. But there is a federal statute that delegated certain powers to the president, and that's what President Trump is relying on. Okay, and that's what they're going to argue all day long. And the other side's going to argue, oh no, you're just not naming 7 countries. Look, we have limited people's immigration from countries for years and years. We all know that. They had quotas, specific quotas for different countries for many, many years. Eastern Europe got so much, particularly Asian countries, got a limited amount, and there was no real question as to why they were doing it. I mean, they wanted a ethnically diverse group, but not too diverse. So Trump is going to rely on that. And if he wins on saying, well, look, this is just 7 countries. I didn't. See, this is the thing that's going to be hard for most people to say this, not for him. He'll say, I didn't mean Muslims at all. It doesn't say, no, I take that back. It doesn't say Muslims. It says, what is it, 6 or 7 countries that are named in the thing, and we've had quotas for countries throughout our history of these sorts of things. More than 100 years we've had that, and the other ones are going to say, no, it's perfectly clear what the purpose was. It was to limit Muslims, period. And they're going to say the Obama administration, was no soft touch on this issue, that Daca was an exception to the usual rule. I would say that the Obama administration deported more people who didn't have documentation than anyone in the past. In the past, we used to let them all stay and say, well, this is it. We pass a new rule. And you remember Reagan did that. I can talk to an audience who remembers Reagan. He did that. He said, I'm against this, this immigration from all these foreign countries. He said, but they're here. I'm going to let them here. But from now on, here's what goes on. And it just gets ignored. Why? I mean, particularly if they're coming from the South, they come in. It's like the joke that someone said was, he's going to build a wall. He says they go through tunnels to get in. Didn't he understand that? So anyway, that's going to be the argument. Now, they're going to say that's the real purpose of this. How do you know it's the real purpose? Because that is what he said originally, and then he withdrew it when they felt he was in trouble, but he's trying to accomplish the same thing. That's what they're going to, and it's a pretty good argument. But let me say one more thing. But then there's another rule, and that is that the court does not inquire as to what the motivation of the legislation or executive thing was. Now, the purpose is not to be determined. That's the rule. Well, it's a rule that is what we call honored more in the breach than in the observance. They do it all the time. And we have some clearly stated rules of interpreting, for example, the religion clauses, which said if the purpose or effect is to do this in respect to religion. Okay, and they're going to say, well, that's what they're going to argue. If I were to predict the outcome, I would say he's probably going to lose. It all depends on Justice Kennedy. I'll take it back. Want the prediction again? Change my mind. He'll win with these 9 justices. She wanted to follow up just for a moment.
Do you think equal protection attaches to the dreamers who are already here that would be subject to deportation?
No.
Okay.
Not if they're here illegally. We don't say illegal anymore. Undocumented.
Over there. Is it working?
Hello.
Hi. I wonder if you could comment on Gill versus Whitford. That's the gerrymandering case.
Yeah.
I think you talked about districting, and I think maybe that's the one you were referring to
Yeah,
earlier. But
that's right.
could you comment on that one that's
Yes.
coming before the court, and what maybe make a prediction?
It is perfectly clear that gerrymandering of various sorts has taken place. Gerrymandering is you define the limits of the congressional district or of the, even if it's a state district, of the districts within the state. And the rule has been plain that if you do so on racial grounds, all right, and then you lose. And you prove it, that it was done on racial grounds. I remember the time that I was clerking, we had the first case like this, in which, I forget, Texas, I think, you know, they called it some dragon-shaped 50, you know, and it was shaped, you know, like this in order to do it, and the court said it violated the rights of the equal protection on the basis of race. That was, but once again, they looked at the purpose. Well, the purpose was so obvious, you know, dragon-shaped, that's right. 24-sided dragon-shaped figure, they said was what was done. Okay, so this does not involve race. This, for the first time, involves political party. Goes on all the time, the Democrats get control of the legislature, and you can only do this once every 10 years. Yes, that's important to remember, that you have reapportionment under the Constitution every 10 years. You determine the number of members of the House of Representatives that you're entitled to, based on population. And so they are what they're going to do here. They've avoided in the past. About 20 years ago, they had a case involving this very thing. I think so. It was just Byron White was on the court, wrote one of the opinions. They had 3 opinions in the case, 3, 3, and 3, and they were, you know, all over the place in determining. So they left it open. I mean, it's undecided. They said in this particular case, they said they've done it so that no reasonable amount of change or something like that could result in it. Justice Kennedy, I remember now, wrote an opinion himself in saying, well, I wish that we had a standard to determine when this gerrymandering according to political party was so extreme that ordinary political processes would not be in a position ever to change it for a long time. And he said, but I can't come up with one. He said, but nonetheless, he said, maybe someone will come up with one in the future, and I decide that we should decide the case on narrow grounds, and that's it. So would I have a prediction on this? Well, if I were fully instrumental, I'd say if these 9 justices decide it, it's all going to come down Justice Kennedy. How he feels about it. I don't know how he feels about it. I'm trying to look at the person who asked me the question. I don't know how he feels about it, and I'll tell you what, I don't think he knows how he feels about it. He'll struggle with it in some way, and who knows. But that's my pretty good prediction is that it's going to be a very close decision. 5-4, maybe under the usual grounds. The thing is, it's, you know, you never know what's going to happen in the next 10 years. Well, you get 10 years worth, 10 years worth of having the districts the way they are, then you may as well do it on a political basis. I mean, you would tell me if there's nothing wrong with might be being clear. You look puzzled and you say, the next time you're going to have districting is 10 years from now. So whatever they put in now, which will be challenged, but it lasts for the next 10 years unless it's declared unconstitutional. That's the only thing that'll change it.
Jesse, given all the complexity we have with establishing political equality in the United States and political access, why do you think the court chose to use freedom of speech rather than equal protection in the Citizens United case? Because it would seem on the surface that what they did was to allow political elites to control the political process, whether they be unions or wealthy individuals, as opposed to establishing a precedent in which broader access to political power and authority would be established under the rules.
Why did they do what they did and decided on free speech grounds? Okay? I think that the people who supported it, which were the big spenders, and people remind me what I was beginning to say because I want to say something else first. I'll probably forget what I was going to be saying. The sociologists have yet to demonstrate who's really benefited by this rule, the Republicans or the Democrats. Don't forget, this is not just commercial, financial corporations. This is unions too. Big corporations, they go predominantly in favor of the Republicans, but they want to cover themselves, and almost all of them, you can just see it. The bigger the corporation, the more they contribute to both parties. They don't want to get hit badly that way. Okay, so as I say, sociologists or whoever studies that sort of thing will say, who's really been the winner over the period of, we've had it for a while now. What did I say, 20 years? Who's are the unions doing better? Unions, by the way, are virtually always for the Democrats. So I'm not at all sure who the winner is of that case. And the question was,
Why did they use?
why'd they use equal protection? Why didn't they use equal protection? Because no one has ever said that money is a suspect classification, which means, look, there is not a law in the world that treats everyone equally. I used to teach this in class and say, got one? What is a law? What law doesn't treats everyone equally? There's none. You say, well, you can't go through a red light. Of course you can go through a red light if you're an ambulance, if you're a police car. You tell me what you can't kill anybody. Of course you can, self-defense. So they all have exceptions, right? There's no law that's, and the court struggles with this. And they said, well, there are some kinds of discriminations that are, the technical word is suspect. Race, religion, although religion has its own clause, the free exercise of religion. Race, gender, which they've now said can't discriminate on the basis of that. They've now made it clear that they're still compelling government interest, still tested the same as race. For some reason, it's illegitimate. I forget the names of children. Illegitimate children. Children born of a married couple that are not married. Pardon? Yeah, that's it's not politically correct, that term anymore. But anyway, so they've held that too, on the ground that the child had absolutely no control over the situation, which is a pretty good reason to do it. But if they say, well, you don't have control of how smart you are either. You got to treat everyone the same, no matter how high your IQ is, and so long as you're not totally out of it. I mean, we don't want to do that. All laws discriminate. So that's why they don't want to fool around with equal protection. Free speech, on the other hand, is subject to very strong restriction by itself, and that's why they chose it. Oh, I'm sorry. I'm not doing this. Whew.
So, free speech, Berkeley, and what's going on now about the restricting...
Where are you?
Here I am.
Oh, here.
What's going on now about restricting or not restricting the right conservative people? I just read that Bannon is going to be coming to UC Berkeley. So, will there be cases about this within our community?
If any, well, that's a nice, will there be cases? I tell you something, if anyone is sanctioned by the government in respect to any of this, and there probably will be, sure, there'll be a lawyer filing a lawsuit in 30 seconds. So that's there. What should Berkeley do? I'm sure you've all heard the expression, the chancellor is between a rock and a hard place. Enormously difficult. On the one hand, we have, in my judgment, good reason to try to, be famous to defend free speech is not a bad thing. I think it's a very nice thing. But you just can't do that. As Oliver Wendell Holmes said, famously, he says the free speech clause does not give you a right to holler fire in a crowded theater. And so there's a limit. And the question is, that's why we have lawyers to try to figure this out, and judges. And what are the limits? I think she's been very courageous in saying this, we want to preserve free speech, but free speech has limits. No one has ever said it's absolute. No one, in a serious way. It's not absolute. The question is, when can you restrict it? And the usual, the formula is, a compelling interest in some stuff. There's some other formulas, but it comes down to basically the same thing. And I think at a certain point, these people are taking advantage of Berkeley, both sides. They're taking advantage of Berkeley's adherence to free speech, both sides. What do they call them? Alt-left, alt-right, I can't keep track of them all. But a lot of them want to, they want to be arrested. They want the speech to stop. If you don't think that fellow Ioannopoulos was very happy the last time when they wouldn't let him speak. I'll show him, he said, what kind of place they are. Free speech, phooey. You didn't observe it at all. So you can't pay any other, you just can't have any easy answer to that. No one can, predict the future. You don't know what would happen if you left him here. You don't know how many people, I guess you can always stop it. But you got to crack some heads sometimes in order to do it. You got to get police to do it. And the thing that adds insult to injury in respect to this whole issue is the cost of it. Here we are, strapped. I saw the figure that we had spent, if you want to add it up, the last couple of times around, it's big. And as for my personal view, and that's all that it's worth, is that as someone who believes very strongly in free speech, I admire the Chancellor for doing what she's doing. I think she is doing you gotta give some deference to what she decides. It's easy to be, in my judgment, on the outside saying, well, why didn't you do this? Why didn't you do that? Could have done this, and so forth. Yeah, you could have, but someone's got to make decisions like this. They're hard decisions, and she's trying the best she can, I think, to try to, A, maintain free speech on the one hand, and not have a lot of people end up banged up on the other, or people banged up worse for people. You know, you can have people killed. It's been known. Happened in Charlottesville, one death, or you know, substantial damage, to substantial expense in many ways. So I don't know. Someone's got. I'm happy if someone wants to say, you know, give their own talk. I'm serious. Give you know your own views on this. I'd like to be. I'll do the cross-examining. I'm dead because I just don't think there's much more that she can do. Got another question?
I read that Steve Bannon, in the interview that ran Sunday night on 60 Minutes, claimed that Mitch McConnell and Paul Ryan were trying to nullify the 2016 presidential election. My question is there a process by which that election might be nullified, provided, for example, that Special Counsel Mueller found reasonable evidence that collusion between the Trump campaign and Russia determined the outcome of the election? And if there is such a process, what would happen after that?
No. I mean, there is a process. There's a very simple process. Impeachment. That is what it's going to take. And it's going to take an enormous, it's very difficult to, you know, they have, you can say you impeach or you convict, all right? Bill Clinton, he was impeached, but they didn't convict him, all right? You can impeach by a majority vote of both houses in Congress, but you can't convict unless you get a 2/3 vote. Now, to get a 2/3 vote takes an awful lot. I think, this is purely my opinion, if Mueller, who by all accounts is a real straight shooter and does not have any, and he's going, put very few limits there. You know, there is a limit to what he was authorized to do. No one's tried to claim anything like that yet. But whatever it is, if they found, if he can demonstrate, not that the Russians try to influence the election. Of course they try to influence the election. We try to influence elections all over the world. So, I mean, that's I don't know, nor do we admit it, and neither do they admit it. But everybody knows that everybody's lying. That's really the way it is. But if he knew that we were working with Russia, that his people, he didn't have to do it. He didn't have to do it himself. If his people, like his son-in-law, knew that he had evidence that would influence the election coming from the Russians, I think that's going to be enough for the Republicans in the House in particular, but in the Senate too, to say that's enough, you know, out. I'd say if they could prove that, he'd resign. That's what Nixon did. You know, we forget. You know, we think Trump, what a terrible man. Well, he's not the same person as Nixon is. But if you want to look and where they stand, you know, on the someplace on the tablet that's being kept, I'm not sure that one is anything. They're very different bad people in a sense. Yes. Oh, I'm sorry. Oh, here we got someone with a...
Mike's over here. Took me a while to get it. You said at the beginning of your talk that liberal versus conservative on the court doesn't mean the same thing as liberal conservatives we see in Congress, for example, or in state legislatures.
Yeah.
And it seems to me that seems exactly the same. Because if cases, for example, like the federal government trying to interfere with the states legalizing marijuana or the sanctuary city cases like that, I'm sure the conservatives would be anti-states' rights and the liberals would be for states' rights because it's a political issue. It's not. So maybe you could explain to me why you think that the liberal conservative spectrum on the court is not virtually the same as the liberal conservative spectrum in the political arena?
Well, I don't think that's easy. I said they're coming closer and closer. The major difference is that the members of the court don't have to report to any constituents. That's and if they think, well, there are a lot of Republicans who thought that Nixon was wrong, and there are a lot of Republicans that think that Trump is wrong, okay? I'm afraid to say that virtually all of them are guided by what they think their constituents say, because they got to run. That's what democracy is all about. You know, we got what we bargained for in respect to the way the president operates and the Congress operates. And we have certain restrictions. At a certain point, we say no. That is, when I say we, I mean the people say no. They speak through their legislators, who are going to go through the impeachment. You know, they actually, I think they convicted. They got. I forget exactly what happened with Nixon. When he saw the end in sight, he just quit. He knew it was over, and I think that Trump will do the same thing. I think the last. Look, I'm no psychiatrist, but just. There are some here. I was going to say none of us are, but there are some here. But you know, we all psychoanalyze him every day. So, it just seems to me that he'll find some reason to resign. You know, I've had enough of this stuff. I don't know. I haven't written the script yet, but he'll come up with something, even if it's not believable. Because he says that sort of thing all the time. He says, I quit, you know, bunch of ingrates here. or something to that effect. Or something that
The past Congress.
I'm sorry, I can't hear you.
The past Congress set a precedent of refusing to advise and consent, as was their constitutional duty, on the appointment of Merrick Garland.
Yes, constitutional right.
Constitutional right.
There's not a big difference between their duty and their right. So it didn't have to. There's been, excuse me.
But could Obama have appointed Garland anyway, despite the fact because they did not act, that he could have appointed them because it was his right as the president to make an appointment to the Supreme Court?
Correct. It was his right to nominate, and it is their right to confirm.
Okay,
And
so I
I
thought
think-
advice and consent didn't mean confirm. Is it actually confirm? Is that the language? Wow, okay.
Yeah, confirm.
Okay.
We confirm the nomination. So let me say this. Obama put someone in. I'll put it this way. I've said this many, many times. Both sides were making a bet. They bet that they were going to win the election. The Democrats said, if we win the election, then we'll not. We don't have to continue with Garland, although they may have been stuck with him, just as a matter of appearances. I mean, they can withdraw the nomination any time. But the Republicans were making a bet. Let me put it this way: if the Republicans lost the election, they would welcome a guy like Garland with open arms. And if the Democrats lost the election, they'd also welcome a guy. He wouldn't be their model, but if they lost, they'd say, well, it could be a lot worse, right? And usually, it is a lot worse. It is with the one appointment that has been made by President Trump, Gorsuch. I mean, he's very, as I tried to indicate today, very conservative. Very conservative. In many ways, he's an effective conservative, whereas Clarence Thomas, although a principled conservative, he's not effective because it just can't, we're not going to turn the clock back 200 years because of the original intent. So did I answer your question? Yes. It is there. They go all. There's an unspoken rule. The last 6 months of a presidency, no one gets confirmed to big jobs. They just sit there. That's true. This was the longest that it's ever been. 14 months, I think, we're without a Supreme Court justice. But both sides said, we're not going to confirm anybody. And both sides, I guess, why the Democrats thought that they could lose the election, I don't know. But they managed.
I have a two-part question, maybe related. Jesse, can the Supreme Court take up an issue on their own without someone bringing it to them? And secondly...
The answer is quickly.
No. No, they can't. Okay. So then the second part is the Electoral College. In order to challenge it, the concept, and do away, who would do it? How would you deal with
the
it?
Electoral College? Yeah. The Electoral College is in the Constitution. That's the way we elect the president. We had good reason for it in the 18th century. Why? Information didn't travel around. George Washington, who was he, the general that won? Oh, he was the general who won that, won all these battles for. They didn't know. So what they did is they said they'll have a bunch of wise men. That's what they were at the time. Make these decisions. They can. They'll keep up with it. They can travel to Washington to pay attention to what's going on, and etc. I myself, I always thought the Electoral College not a bad thing, even though it is not democratic. I mean, majoritarian in the strict sense. But look, people like Gore, he just gave up when they got I forget the state, Texas? No, who was it? Florida. That's right, Florida. Sorry, thank you. He could have challenged it all away and so forth, but he believed in the system and he did it. I admire him a lot for that. Nixon, the first election that he lost, if you recall, to Jack Kennedy, it was Illinois. You think back to that. That was the state and it was perfectly clear what was going on in Illinois. What was that machine? That was, the Daily Machine. That's right. You had to control the election. That's just the way it came out. And I thought, well, Nixon is going to do something about this. And look, I don't hate very many people, but I did hate Nixon. All right? That's the one that I hated him. But he acted like a gentleman when he simply said, well, I guess I am not going to dispute this, despite the fact that they stole the election. Lyndon Johnson had that happen to him once when he was running earlier on, not for the presidency, when he was running in Texas. And because he said, they stole all the votes for him. So he had a remedy for that. He stole all the votes after that. Whatever he stole, whatever it was, he'd find out what was going on. He'd steal that. But that's a democratic system at work. I'm sure on this group. You know what Churchill said about democracy? He says it's the worst form of government. He said except for all the others, and that's what we got. We don't have a perfect form of government, but. It's been very good to this country, and it's been very good to people like me, a first-generation American, and both of my parents were immigrants, so I understand the phenomenon. Okay, sorry.
So I want to go back to the Supreme Court. So currently, justices are appointed for life.
For life, yes.
Given that the life expectancy has now become quite extended, is there any, what's your opinion on possibly limiting their appointments and not allowing them for life?
Yeah. I have a very unpopular view about that by most people. I would not appoint them for life. I would appoint them under circumstance. But why do you appoint them for life? Because the notion was you don't want them making any decisions based upon how they can take advantage of it after they get out of office. Well, I think it would be costly, probably, to do this, but I would give them an enormous pension. And these presidents, former presidents go out, they make a lot of money afterwards. Speeches, books, all of that stuff. Well, I guess I'd let them write books and give speeches, but I would give them enough that there would be no incentive but I would stop them from any engagement in politics, whatever. And I haven't worked out all the details, obviously. But I think for the very reasons that you gave. I mean, they stick around for 50 years now on a Supreme Court in these positions of enormous power. Enormous power. They can't decide a lot of things, but things they decide are pretty important.
Given your historical perspective, do you think that today's court is more politicized and polarized than previous courts? And if so, do you think that's having any impact on the public perception of the court's legitimacy?
Well, I think that the short answer is yes. As I said, I think it's terribly unfortunate that the 4 liberal-leaning justices were all appointed by Democratic presidents. And I said this today sometime during the talk. It's the first time in our history of these split courts, and we've had them. But a number of the people in the New Deal that voted against Roosevelt were Democrats. They were the whole Southern Democrat. They were all Democrats, different. But now things have changed. And the question was exactly what? Oh, yeah, I think it's more likely than it ever was before. I still think that these are people of integrity. Don't misunderstand me. It's just that when you interpret such vague language of the Constitution as due process, what the devil does that mean? Or equal protection. Everything discriminates against somebody. I say every law in the world discriminates. So we give them enormous authority. And I think they respect that. And I think at a certain point, they jump. I'll give you an example. In the famous healthcare case, Obamacare case, in which Chief Justice Roberts, a conservative, voted to uphold it. Why did he do that? Because I think, this again is all my own view, I mean, I'm sure other people would agree, but he felt it would look crappy, in a word, to have this highly politicized issue of health care decided by a 5-4 majority of the court, in which all the people who went, let's say they would strike it down. That's what they would have done. They were all appointed by Republicans, and the people who wanted were all appointed by Democrats. So he said, "No, I'm going to do it." He's, I was going to say he's a very clever man. He is. He's very smart, terribly smart. They're all smart. And he wrote an opinion that's largely ignored. That is the reasoning. It was a very narrow opinion. The major argument was that it's valid under the Regulation of Interstate Commerce Clause of the Constitution. I went around saying, that's a slam dunk. Of course it affects interstate commerce. It's an easy one. Of course that's what they'll do. Well, I was wrong. He went on the taxing clause. Hadn't been used in 40 years to uphold it. And he had a perfectly reasonable interpretation of it. He said this is a tax. Obamacare was a tax. Well, it was. I forget. He had a few reasons why. You didn't have to. You didn't have to pay. I mean, it raised some taxes, some specific taxes, but it certainly wasn't a tax. It was a regulation to give health care to everybody. That's what they knew. So, I think your question is, do they rise above politics? I think that Roberts felt that as Chief Justice, he had an obligation to try to preserve the notion that the Supreme Court is independent and not simply another branch of political parties in government. That's what I think. And I think there is a limit to where they're going to go. But I think they're going more and more the same way. But I think they have that feeling. I think the others of them, they think that what they're doing is the right thing to do. We're going to see political parties changing around too in our existing government. All of a sudden, Trump's best buddies are the two Democratic leaders. So yeah, Republicans think he's a deserter, which he will be if he carries through with what he says. There's no reason to believe that's true either. No, he doesn't. You can't get upset about what he says because it's changeable till tomorrow. Huh? Tonight.
Is there one last question here? There was one here. Okay, so we have time for one more.
Sir, given your legal background and your being so highly informed about our country, what is your diagnosis for the current health of our country?
The current
health of our
health?
nation. HEALTH, health of our country.
Well, I'm saying something that's just obvious. It is an unfortunately terribly polarized political system that we have. The health of the country, financially, stock market keeps going up 200 and some odd points yesterday. Why? I don't know. I mean, if I knew that, I done some buying before that the day started. So you just don't know. But we are having the longest, in terms of the market, a lot of lower middle class people are dependent on the market too if they got their money tied up in funds of one sort or another. So our health, our health about principle, terrible. It is just people unwilling to do what they well may believe that is the right thing, but doesn't work to their personal advantage. That certainly was not true in prior years. People went off to war. Even if they were conscientious objectors, they still did things indirectly to support the war. I knew people who were conscientious objectors back then, and they were against the war. They certainly didn't like the Axis, but today I think we're different. I think we're a very polarized and relatively closed-minded group of people. So, how's that for a? Thank you.
I'm sure there are many more questions you'd like to ask, but we can't have this room for any longer at all. So I hope to see you all again at the next time, 28th of September, for Amanda Tyler. And thank Professor Chopra again.